thank you everyone for being here. Thank you to Chambers, especially thanks to the South African Chambers of Commerce in Mauritius, to Richard, Kathleen and Laurent for organizing this event. And thank you, Roger, for taking your time, your very busy schedule, to come here and speak with us. And thank you to Anjana for also taking your time to explain what MARC is doing. Well, my presentation today will be very short, rest assured. I'm not going to go into any detail in relation to Mauritian law. I don't need to, because we have the ancestral model law. As Roger just pointed out, this is the, model law? Is the reflection of the best standards in arbitration internationally. They have been prepared, the law has been prepared under the auspices of the UN. So all countries have sent their experts to work on them. The law has been reformed in 2006, so they're very up to date. And our legislator has adopted this law and has enhanced it. I'm going to, I don't need to set the context of investments. All I have to, before going to the law, I just want to point out that we're talking about going to arbitration in relations to investments. So we will be talking about obviously inserting arbitration clauses in corporate structures you might be setting up, especially the ones that will hold global business licenses, contracts, whether with shareholders, other business partners, third parties, local companies, foreign companies, and obviously investment will include transferring funds and also technical know-how. That's very interesting, and I'll come back to that later. And as you know, things can go wrong. So basically, for breach of contract, you will need a remedy for breach of contract in a private transaction. But also very importantly, as an investor, South African investor in Mauritius, you will need to know your rights against the state in case things change in the future. Okay, Roger and Anjana have already spoken about why arbitration is the preferred method for you. So I'm not going to go in detail on this point, but you need to have basic understanding of the legal framework, which I'll try to talk about over a few minutes, and you'll need to take appropriate precautions. So now I'm coming back to the unstrong law. So how has our legislator enhanced the ancestral model law? Basically, we have supported it with a proper procedure in Mauritius. For instance, we have set up a panel of judges, specialized judges from the judiciary that will listen to all arbitration cases. And for example, in the UK, you will get any high court judge will take an arbitration case. Sometimes you will get a high court judge who is specialized, sometimes you won't. Whereas here, we have 6 designated judges, and each time there's a case relating to an international arbitration, a panel will be constituted by 3 of those judges. And these judges will hear the case at first instance and give a decision. And any party will have an automatic right of appeal to the Privy Council, and that's the final appeal. So it's very short, and you already have 3 judges at first instance, so we're really trying to make sure you get the right decision at the first instance itself, And in case there's a problem, you can always go to Privy Council, which is highly respected as well, and it's very independent and neutral. My experience dealing with arbitration cases in Mauritius, I think, leaves me with the conclusion that after the 2008 Act was passed and after the 2013 procedural rules, the Supreme Court rules relating to arbitration cases were passed, the procedure is extremely fast and efficient. I've rarely seen in any jurisdiction a court giving a final decision in relation to an arbitration case, obviously in relation to an aspect under Mauritian law relating to arbitration proceedings within a year. To tell you frankly, this is great. And it's been done, I've seen. I've also been able to obtain interim measures very, very rapidly, which have been ex parte and which have been confirmed later also very rapidly. Additionally, another enhancement that we have in Mauritius is the negative effect of the principle of compétence. Well, basically what this means is that the judge will not intervene in order to verify the validity of an arbitration clause. This is the most commonly used excuse by defendants to delay matters or to even prevent arbitration from happening, because they go to the domestic court and they say, look, I don't agree that this clause, this arbitration clause is valid. So prevent the other side from going to arbitration. Well, Mauritian courts will say, we won't even look at it. You go to arbitration, let the arbitrator decide if it's valid, get your award, and then if you want to enforce here, we'll see if we'll let you enforce. Or if the arbitration is seated in Mauritius and you want to challenge the award, then you'll do that at a later stage. So that prevents parties from disrupting arbitration proceedings. And this principle only exists in France, actually, and now also in Mauritius. So, in effect, the legislation really protects the autonomy of arbitration from the beginning to the end, and then limits court intervention only in relation to enforcement issues. Even in relation to obtaining interim measures, you can go to the arbitration tribunal, obviously, to get your interim measures. The MARC, in the new rules, and Jana mentioned that I should speak about the new rules, so that's an opportunity. We expect to introduce the emergency arbitration proceeding, which is before you've been able to set up the arbitral tribunal that's going to resolve your dispute. If you need an urgent measure of protection, you go to the center, you say, I want an emergency arbitrator to give me an interim measure. And you can get that within days. The arbitrator can be appointed within hours, and you can get that measure immediately. So, to come to the point I was making, if you have adopted such a procedure, but you go to court for your interim measure, the court will say, I'm not going to give you an interim measure, because why didn't you go to the center? Why didn't you go to the arbitrator? He knows the case, right? So this is the idea, because even alleged attempts to seek interim measures are also used as dilatory tactics. So this is how far the legislature goes in Mauritius to protect the autonomy of the arbitration proceedings and make it truly independent and detached from the system, the legal system. Let's move on to the next slide. Right, yes, so to benefit from the legal framework, when you're dealing with, we're talking about commercial arbitration for now, and later on, in relation arbitration to investor-state arbitration. So you need to insert an appropriate arbitration clause. For GBC companies, I think a common mistake is to insert different clauses between, I mean, I've seen so many of them, clauses for a different institution or a different seat of arbitration in the constitution. For example, Mauritius, because you want to get substance in Mauritius for tax purposes. But then shareholders enter an agreement in relation to other issues relating to the company, and they say, well, we're going to go to arbitration elsewhere, Switzerland, you know. And this doesn't make sense, because these disputes will be related, and then you're going to have to deal with two arbitrations. It doesn't make sense. Always take the clause that's identical to the one in the Constitution and insert it in your shareholder agreements. That's a common mistake. That's why I wanted to point this out. But appropriate arbitration clause also means institutional for me, as far as I'm concerned, because my experience in relation to ad hoc arbitration, I don't even want to describe it. So don't go there. Just prefer a respected institution. For example, the MARC, which has a truly independent international arbitration court, because all the major key decisions are taken by that court, you know, and it really gives neutrality, guarantees neutrality in resolving your dispute. Choose Mauritius as a seat because of all the reasons we've mentioned, if it's not just for the issue of substance for tax purposes. And when you choose, my advice is that, well, you have the, for example, let's look at the arbitration clause that's in the blue booklet. Thank you. I think this, yes. Now, this is the model arbitration clause. There is an issue in relation to arbitrations that might eventually be considered as domestic. Why? Because let's assume you have well, you might be a South African national who's simply a shareholder of a domestic company, or you might have a South African company, who might be a South African company, that's the shareholder of the domestic company. And this specific purpose vehicle you set up in Mauritius in relation to any project enters in agreement, into an agreement with a Mauritian party. What happens is that you could well be seen as being entering into a domestic transaction, so that you fall under domestic arbitration law. Our domestic arbitration law it's all right, but it's a bit old. It needs reform, right? It was passed in the 1980s based on French Code de Procédure Civile. The French have already updated theirs in 2011. Ours is still the 1980s version, or even a bit older than that. So the good thing now, good news, is that under the International Arbitration Act, that is the one that's based on the ancestral law, the one that we are proud of, it gives parties the choice to say, even in a domestic arbitration, even in any case that would otherwise be considered as a domestic arbitration, to explicitly state that it is the International Arbitration Act that will apply. So my advice would be to insert a small sentence after, or any arbitration clause you choose, to say the arbitration will be governed by the International Arbitration Act, so that nobody down the line will come and say, no, this is domestic arbitration, and then you fall under the old regime, which is less efficient. Now, moving on to your treaty rights, I think this is very important to know. in fact, there's a bilateral investment treaty between South Africa and Mauritius. It was passed in 1998. It was for 10 years. After 10 years, it would stay in force until a party gives notice. That is, either South Africa or Mauritius gives notice to terminate. This hasn't happened yet. I don't think it's going to happen soon. Even if it does happen, the treaty provides that you'll still be protected for 20 more years. So termination will not occur immediately, it will occur in 20 further years. Now, what protections do you have under this treaty? And it's very, very interesting, very important to know this. Basically, the state, as an investor in Mauritius, when you invest as a South African investor, the state is guaranteeing you that it will give you fair and equitable treatment and full protection, and that it will not take unreasonable or discriminatory measures. Now, this is extremely important. This is very summarized. Every single bullet point here is a chapter in an investment law textbook. But this is extreme, just for you to get the gist of the matter. Imagine, okay, at the moment Mauritius is very welcoming to South African investors. Imagine tomorrow you get a government that has a completely different policy and says, no way, we're going to get these people out. We want to change something. Right? You don't care. Your asset is protected because the treaty protects you. Because any change in policy is not fair and equitable treatment. It's not full protection. It's an unreasonable and a discriminatory measure. So it's very important protection. So what you would do, before I go to the remedy, so there's also national and most favored nation treatment. National treatment means that you will not be discriminated against in relation to any advantage national Mauritian would get in making an investment. So you get the same treatment. Most favored nation treatment means that if tomorrow Mauritius enters into a treaty, say with Australia, and says, okay, Australian investors will be given that advantage, you get it too, automatically, because we have already guaranteed you the most favored nation treatment. So if we favor another nation, you get it too. No expropriation without compensation. Obviously, if the state has to take possession, ownership of any asset you may own, it has to give fair and prompt, adequate, and effective compensation. And obviously, you're guaranteed free transfer of your investment returns. This goes without saying. And there's an umbrella clause covering other state obligations, which will cover any contracts you may have entered with state organs or state-controlled companies, so that these contractual obligations are elevated to treaty rights. Now, to benefit from arbitration under the bilateral investment treaty, basically, I think that there are just two requirements. Your investment, what qualifies as an investment? Money, obviously, assets, purchasing assets here, transferring assets here, but also copyright, trade information, intellectual property that has value. It's considered as an asset. If you get a concession in relation to exploiting any resource, or that's also considered as an asset, although it's sort of counterintuitive, but yes. So the definition of investment is extremely wide, and I doubt that. Well, there might be certain areas where you might have difficulties, but it's hard to even identify them. You see, that's how wide it is. Now, as investor, you need also to be an investor. You may know that there's already an investment case, one or two, but one of them against Mauritius, where this issue is arising. When you invest, you must invest as, the general principle is when you're investing as a South African. You're not investing as a Mauritian, because Mauritians don't get treaty rights. So, and obviously if it's a when it's a company, the issue doesn't arise because the shareholder is an investor, right? Even if the company is a domestic one, you can always bring an action as a shareholder against the state if the company suffers harm as a result of government action, right? But as a national, if you're investing as a national, that's when the issue arises, and that's a grey area in investment law. But I have looked at the treaty, and my view is that even if you're dual national, because if you're staying here, you might even want to take Mauritian nationality, you still get protection. And this is quite rare, because normally you don't. Normally, once you become a national, the state stops protecting you as a foreign investor. But under the South African Mauritian BIT, you can get your nationality and still be protected as a South African investor, so that if tomorrow anything happens to your investment, you can take the state to arbitration. And under the treaty, that was on the slide a bit before, but I just realized I missed it. But what arbitration are we talking about? Is arbitration under the treaty is either before the ICSID, which is the International Center for the Settlement of Investment Disputes set up under the World Bank, or it's an ad hoc arbitration under the UNCITRAL rules. Now, well, ICSID it's quite, you can go to the ICSID as an investor because Mauritius is party to that convention, so we have accepted to comply with the Washington Convention. And however, Mauritian investors finally can't take you to take South Africa to the ICSID because South Africa is not a party. So, but you have the choice as an investor. You can take Mauritius to that tribunal, or you can go to an ad hoc tribunal set up under the UNCITRAL rules. And in that context, it's not just so an ad hoc is not to be preferred in commercial arbitration, but in investment arbitration, I think it's less damaging. ICSID is still better, but you still have, for example, if you go under the UNCITRAL rules, you have the Permanent Court of Arbitration of The Hague that will intervene to look for an appointing authority to set up the tribunal, for example. So you still have some support from institutions. So basically, you will have access to a remedy before these international, very neutral tribunals if the state breaches any of its obligations. I think I've reached the end of my presentation. Or last message: make sure you protect your investment. Thank you.